Hi, everyone. We are live and unmuted. Starting very shortly. Attendance work, please.
You see that? Don't worry. We're here in the matter of S1 SC 41374, Jaramillo versus Whitehead. Mr. Harrison, I understand you've reserved 15 minutes for your main argument and 5 minutes for rebuttal, with Mr. Nance arguing for 10. Is that correct?
Yes, Your Honor.
And 15 and 15, Mr. Eli, Mr. Al.
That is correct.
Thank you very much. Mr. Harrison, you may enter your appearance and proceed.
Thank you, Your Honor. Madam Chief Justice, may it please the court, I'm Carter Harrison for Real Party and Interest Appellant Rebecca Dow. Where this court has allowed what I'll call form-based nominating petition disqualifications, most notably under 1-1-26 for incorrect or modified information in the header, it has focused on whether the information was properly conveyed to voters. Now, obviously, it was back in the what I'm calling the traditional hard copy days. It was the same piece of paper that the voters saw and that ultimately ended up with the filing officer. But what this court wrote in Morper focused the analysis in a way that we should focus here, which is, quote, the consideration crucial to determining whether a nominating petition is invalid under the election code is whether a voter was apprised of all of the information required by 1-1-26A prior to signing the petition. That is the focus here as well, which is...
Let's focus on two verbs that go to your argument. So one statute says gather and the other says file. To me, those are different. Legislature used two different verbs. I need you to address that. I understand the Morper argument, but why would they use the term gather for the electronic part, but tell you directly, your client directly, to file. And is that a distinction with the difference for your client?
So Your Honor, the term gather is used a single time in the entire election code, and it's in the new 1-1-7.2E. Now, 1-1-7.2E sets up an online system, a secure internet application for quote unquote gathering. So it does not expressly allow the filing officer to go on and pull petitions from the portal, what we're calling the portal, nor does it expressly allow printing. And it certainly doesn't expressly allow the aggregation of a bunch of different petitions into a 10-line petition that is never seen by the voter and printing that out. So my position isn't that any of that is illegal. I think it's all implicitly authorized by the subsection. The Secretary's position is that, well, yes, it implicitly allows us to aggregate a bunch of different petitions into a single one and print that out.
My question is a little different. The legislature says file. They attach file with a form, a nominating petition form, and that was not done in this case. I mean, we can all concede the actual statutory form was not done. There were the screenshots, but not the form. That's my question. You gathered them on the electronic portal, but what was filed, there's still that separate requirement that it be in the form in the statute, and that wasn't done. That's where I'm having difficulty.
So what the form, the statutes that go to the form of the nominating petition, we argue go to the original petition, which is what the voters, the emphasis has always been on the interaction between the voter and the petition, which again, back in the traditional hard copy days, it was the same piece of paper. So there was no actual distinction. Here though.
You were working really hard, and you do this papers as well. You have this logical leap from the old paper petition days. Well, we still have paper petitions.
We do.
So it's not as though those went away. There's a convenience factor with the Secretary of State looking at these things and saying, you know, they qualify, but it still requires the filing of the paper petitions. And that's what's missing here. I mean, it's a really simple step. Done it a number of times, as have my colleagues. And so it's not as though the paper petitions don't exist anymore, and your argument stems from the idea that everything is electronic now. So I need you to explain to me how you logically get there.
So paper, what I'm calling traditional hard copy petitions, which as you noted still exist, although they were not used by Representative Dow this cycle, have to be turned in person because otherwise the filing officer doesn't have the originals. The originals are, there's no question about what an original is in the context of a traditional hard copy petition. Online, our position is that the originals, which are required to be, which are the ones that are filed with the filing officer, retained by the filing officers, are the things that are signed by the voter, not a later produced aggregate that the voter never sees and is printed out.
How were they filed? They were submitted for a purpose.
Mm-hmm.
But how are they filed consistent with the legislature's intent in the statute? Because the statute suggests another step, that you file your declaration and you file those petitions. And that's what didn't happen. That goes to Justice Thompson's point. That's what didn't happen.
So we would point to the very similar statute in the Financial Disclosure Act, which is when you have a financial disclosure statement, which again is a required filing. It's not in the election code, but it is required at the same, I guess the quote is, file with the proper filing officer a financial disclosure statement at the time of filing a declaration of candidacy. So it's a filing day document. The Financial Disclosure Act, long, I want to say 9-section act, nothing about online, electronic, digital, et cetera. But those are now a mandatory online filing. Just because the secretary set up a portal, and that's how you file them now. And we would say the same thing is true of the nominating petitions, the
Despite
online
the
portal.
Secretary of State's position that those aren't the instruction, that is not the path. And that there was clarity about what the path should be, and it wasn't met here.
So we disagree that it was clear. First off, the Secretary of State didn't promulgate any rules. 7E clearly seems to contemplate that the Secretary should develop rules for the use of the portal. What we have is, you know, a couple of references in a, what is, I'll concede, a prestigious publication, the Candidate Information Guide, most candidates are aware of, although they use it as a reference. They don't typically read it from front to back. And then some stuff that most candidates are not aware of. I mean, there's a flyer that the Know Before You Go flyer, a social media post. Those are just not adequate. Those are no substitute, certainly for rules that carry the force of law, Your Honor.
Mr. Harrison, I've got a related question. In your declaration at page 12, you have a picture of what the voter sees when they go to sign a petition online, where they pick a select a digital signature. There's a preview, then there's 4 lines there. Then you have what the computer generates as a PDF. If you have a picture of that on page 16 of your declaration. And then on page 22, there's a photocopy of what was filed with Representative Dow's declaration. Which of those 3, if any of them, is a nominating petition?
So,
And I'm asking this question globally. What is the nominating petition in this case?
we would say that the true original nominating petition is that first document on page 12. It's what the voter sees. What matters is what the voter interfaces with. And that goes for both, and that goes for the information that is apprised, to use again the argot of Morper.
Does that screen, whatever it is that comes up, does that strictly comply with the statutory definition or depiction of what a nominating petition is? Does it strictly comply?
It complies with it. It conveys the information required by 1-1-26, which is the only section that allows disqualification or invalidation of petitions if the information is not portrayed. But it actually doesn't comply, nor does the 10-line format that the secretary uses, the right thing to file, comply with all the formal requirements of 1-8-30. For example, the line spacing is wrong. I took a ruler and measured the line spacing doesn't match the statute.
I think we're really focused on that though, and that's not, I think, the tenor of the senior justice's question. If what's on page 12, to your argument, is the nominating petition, it fails substantially not in a measuring the line kind of way, but in the substance kind of way. It fails the statute. Then you have what's on page 16, which is, as you would call, kind of the old school version. And it appears to actually have kind of the critical information for the voter. And so that's why I'm curious about that you're landing on the electronic one being the picture of perfection.
So I actually respectfully disagree that not to be critical, but the filing system somewhat is low resolution. That is the header. And from on page 12, and Ms. Behill authenticated this at the hearing. That's the header information. I, the undersigned, and it gives all the normal header information required by 1-126.
And maybe it's because it's really hard to read.
Now the big, no, and that's, I agree. The main thing that it doesn't, I mean, the way that this deviates are things that are not disqualifying under 1-1-26. It contains the candidate's name, the position they're running for, including the seat number, their address, the county, et cetera. All that information is in there. So I don't agree it doesn't contain the material information. The big thing, the thing that makes it different from a traditional hard copy is you don't see who else is signed. Also, the secretary set up a portal to ask for additional information of the date of signature, which is interesting. I think it's fine, is interesting, but it's
kind of immaterial.
But the point being that if we're going to get criticized for not meeting the 1-8-30 requirements, I think it's fair for me to point out these 10-line formats that the secretary uses, the quote unquote right format, don't comply with any of the 1-8-30 stuff. And so I'm not trying to be nitpicky by saying the line spacing isn't right. It doesn't actually have any of the same information. But if we're going to get criticized for the 1-8-30 form requirements, I think it's a fair counter.
Can I focus you on this? So the district court found that the screenshots of the nominating petitions did not enable or allow a voter to review and challenge the nominating petitions. We've been talking about what the voter knew when they signed the petition, and from that perspective, how, under the circumstances of what your client filed with the clerk's office, would someone be able to review and challenge the nominating petitions?
Thank you. And that is what I wanted to segue into, which is this entire challenge is done not to vindicate the right of a voter to be properly informed before signing, but of a potential challenger to vet a candidate, which is not totally illegitimate. I think there are some valid points that probably the secretary should have filing officers produce the things off of the petition, which, by the way, she should do even for, if I print out a streaky copy, why should that be the one that's provided to potential challengers? I think that probably is something in the future filing officers should pull from the portal and give potential challengers, members of the public, and what we call a copy of the original, rather than whatever was turned in paper. But so sort of, again, from that perspective, even taking that perspective as a given, which again is not as important of a perspective as the voter's perspective, there's all the information here, namely because the VINs are available. The VINs are better information than you can get from even a traditional hard copy petition, in that you plug them into a database that you're required. The rule now requires you to have access to the form of database. This idea,
Who is you, allows you to have access.
I'm sorry, to a potential challenger, someone who wants to file
Anyone off the street can request access.
So anyone off the street can request a copy of the nominating petitions. I tend to agree with the plaintiff that in the future, they should probably get something pulled off of the portal, not whatever happened to have been turned in. Again, that goes for not just people in Rebecca and Ms. Dow's situation, but anybody.
So in this circumstance, if a citizen off the street walked in and asked for Representative Dow's petitions, they would receive what's on page 22.
Well,
Correct.
that's what they in fact received, which I've got a couple answers to that. First,
Okay.
what they in fact received was adequate because they have the VINs. Now the plaintiff points out there's a single sheet that the VINs are cut off. Okay, throw those out. The rest have the VINs. You can plug those into any database and get the address. And again, it's a unique identifier, unlike a name or any of the information that appears normally on a nominating petition.
As voters.
And these databases, there's been a suggestion, well, what if you're a good old fashioned, you don't have a database? The rule requires you to have access to a database. Now, that can be going into the clerk's office and using theirs, but you now have to show, like, the rule requires you to say what searches you ran, who ran the searches, what permutations of names, because the rule was written back in the traditional hard copy days, where a lot of times someone would write an illegible, part of their name, and you'd have to search a couple permutations of the different name. These VINs are in fact superior. So the idea that they didn't have the ability to vet a challenge is not accurate. And in fact, yes, this was the first thing that the plaintiff got when she requested from the clerk nominating petitions. There was no follow-up, and I would suggest that's because they didn't want a bunch of pre-verified, twice as many as required, pre-verified online petitions that are just going to be valid. What they wanted was this argument. And I see that I'm out of time, I believe, Your Honor. Unless Your Honors have any more questions.
Yes, thank you. Sorry. This is actually, I'm a little embarrassed to ask it, but I'm not following. I am not a resident in District 38. I am not an election observer. I'm not a member of a political party. I'm not employed with one. Guess I'm a member of a political party, but I'm not employed by one. I don't meet all the qualifications. Do I have access to this database? Because you're making it sound like everyone has access to this database, and I'm just getting a little confused. Does everyone have access to the database?
So to be clear, so the nominating petition portal, the plaintiff, is that the database you're referring to?
The database where you said you enter the VIN number and you can get the address of the voter, that database.
So the answer is anyone who wants to to file a nominating petition challenge needs to get access to some form of a database that can run these VIN searches, because the rule requires you to say requires you to give it the information you input into that database. And the reality is there's no right to file a nominating petition challenge without having done the work of accessing one of these databases. So
Can I just walk in, like I live in Albuquerque, and I walk into the clerk's office and say, I'm going to sit here for the next 10 hours and you're going to give me access to the database so that I can do this work. Is that what you're suggesting?
yes, and I've done it before.
And is that in the record?
It's in rule 1-0.
The fact that it's that easy, is that in the record? Or is this your argument because you've done it before, even though you probably have access to a database sitting at home too, because of your relationship to the party?
And that is the substance. In practice, obviously, many of us have political party run things, but
So, yeah.
but the fact that the public has access to these databases through the clerk's office, I believe, is in statute, and this is something that, and I believe we cited in the same area where we described the VIN and how the VIN can be used. I think we cited the statute that describes how that works. But the idea that folks are out there actually filing nominating petition challenges in court just using Google, or folks who maybe don't even have internet, is just not the case. Like I said, the rule actually requires you to describe your interface with the database. And so as a practical matter, the VINs are superior. Now, again, that all concedes, of course, that all that the court looks at is what in fact the plaintiff was given. What I would suggest again is that the plaintiff did what I would do if I represented the plaintiff, which is I don't want Representative Dow's nominating petitions that are just going to be valid because they've done through the online portal, which authenticates them. What I want is this exact argument, and obviously it succeeded. So thank you, Your Honors, unless there's any more.
Thank you. Mr. Nance.
Thank you, Your Honor. May it please the court, my name is Adrian Nance, and I represent Sierra County Clerk Amy Whitehead, the filing officer of the House of Representatives, District 38. This court reviews the issues here de novo. The district court is owed no deference to the questions of statutory interpretation. The county clerk's interest here is narrow but critical to ensure that 122 voters who submitted these petitions were given voice in the electoral process.
So, Mr. Nance, let me ask you the same question. What is the nominating petition in this case?
In this case, Your Honor,
What is the nominating petition?
That's a great question, Your Honor. The nominating petition in this case, well, what was filed was the, as you can see, the screenshot, but I believe that it contains all of the information that's necessary. It does not. I'm sorry.
In continuance of and not interrupting the justice's question,
Yes, sir.
that in answering that, you have to tell us how that is the same or different from 1-830. And I see it as different. 1-830 has a form in the statute that is not what you were describing to the senior justice as the nominating petition form that was filed.
I understand, Your Honor, but respectfully, it doesn't affect the validity or the authenticity of the signatures or the core statutory requirement, which demonstrates support from qualified voters was satisfied.
Can I clarify something, counsel? So, and I'm looking at page 22 of the certificate of counsel of Representative Dow. This document is what you're saying is what was the petition signatures that was officially filed, the screenshot.
The screenshot, yes, yes, Your
Okay,
Honor.
so you're making a different argument than the representative is as to what what was filed.
I would say it's slightly different. I'm saying that what was filed does allow the candidate or a challenger as was discussed earlier, to do what a challenger might need to do.
But it doesn't list who the candidate is, where they live, what they're running for.
That's correct, Your Honor, which that information is held at the Secretary of State's database. It already exists. It exists, it's complete, and it's already been validated and cross-checked.
That's not what was filed, and the statute requires a document with the complete information to be filed. I mean, I think of like our clerk's office, something could be dropped off and they say, this is for information only, as opposed to filing it. We would not consider it a filing. And so that I struggle with
Absolutely.
That physical act.
Absolutely. I understand that, Your Honor. And I understand that it certainly is a mandate as prescribed by law. But that said, there's no remedy with that mandate. There's no remedy in the statute that says there should be a disqualification based on that shall. Really what shall ultimately does, it says what must be done, not what must happen if it's not done perfectly. And that, brings up a key problem here. The legislature uses the word shall, but provides no remedy for non-compliance. And when the legislature intends disqualification, it says so explicitly. It did this in 1-126. It did so in the signature invalidity provisions of 117.2, and it did not do so here. In this matter, when the district court was faced with silence, the district court selected basically what is the most draconian remedy, total disqualification and disenfranchisement of 120 voters, 22 voters. And that remedy is not in the statute. And that remedy is not supported by precedent, and it's not necessary to enforce compliance.
You, the district court, just because really the conclusion of the district court was focused on the ability to review and challenge the nominating petitions. Do you have a response other than what was already provided as to how a person who wishes to challenge, even a person that's not working for a political party or an opposing candidate, how would they go about challenging it based on the information that was in fact filed?
Your Honor, I would state that the way that can be done is with the names that are on there, which again are already been pre-qualified and pre-validated, as well as the number. So that information can then be cross-referenced with either the Secretary of State's portal theoretically, or certainly can be cross-referenced with the voter rolls. In this situation, you would simply need to look at somebody's name and see if they're in the voter roll.
So what if it was a name like Mary Garcia, where I'm guessing, don't know how many, but there's a lot of Mary Garcias, I suspect, who live in New Mexico or who live in that particular area. The name seems to me like it would be insufficient to do a challenge, but I'll let you explain, because I feel a little lost with the database thing and some of the talk.
Your Honor, I think that, there certainly can be problems with an individual name. Certainly maybe a John Chavez is a very common name. And there may be issues with those particular names, but that said, I would say that for the vast majority of names, you can certainly discern whether that name is on the voter roll.
What if they were all John Chavez? I mean, we've got to think, we have to write something here.
Right.
What if they were all John Chavez or all John Chavez and Mary Garcia? What would an off the street, not politically connected person do? Because I think that's who we have to think about here in terms of who can challenge. How would they go about doing anything if we're relying on the screenshot?
I think the second part of the screenshot, which goes back to Mr. Carter's argument, would be that unique identifier number, which I believe is on.
What mandates the Secretary of State's office or a clerk's office to give that person access?
I would think, Your Honor.
I've now pulled up the statute. I
Oh,
don't think it covers, the average Joe.
The average Joe. I would argue that certainly under our system, certainly possibly with Inspection of Public Records Act, I'm not certain. But
IPRA
15 days.
is 15 days and you've lost your deadline. I mean, it's not workable. IPRA is not a workable solution. And I don't know an IPRA officer worth their salt that doesn't say, I
They
need
need,
more time.
need more time.
Yeah, and so I am curious because Mr. Carter seemed to suggest statute required it. But my reading, I think it's 11113 index of voters is limited to candidates, political parties, people who are kind of inside baseball. And so I'm worried about that average Joe and how they would get
Certainly, and
access.
Your Honor, I think that one way you could get access, which is certainly something that could have been done in this case, you file a challenge to the nominating petition. I would think that in the response, you could request those documents and they would certainly be
It's
provided.
a Rule 11 problem if you just file a challenge and you don't know that there's anything to challenge.
I think you might, but I think the core issue that we have though is that ultimately there is no remedy in this particular situation.
Can I ask you a question about 117.2? In section D says the procedures set forth in this single section shall be used to validate signatures on any petition. And then when you go to section E, which is the section that provides electronic ability to gather signatures, the legislature says the secure internet application shall provide for the ability to verify. Is there a difference between its use of validate in paper petitions and verify in electronic petitions?
I think that based on the traditional method of gathering signatures, when you say when a traditional signature, you can look and discern whether or not that person's signature is the same person's signature in another case. You can, I don't know whether it's a check, whether they signed something, or it looks like, or maybe if it looks like the same signature, that somebody wrote their name, someone else's name a bunch of times. So I think that is very different than what is electronically, because electronically it is not a real signature. It is you type in your name and it is some sort of facsimile of a signature, just like you do when you sign a bank account. It's not, that part's not real. So I think there is a.
Can I ask you a question? In Charlie v. Johnson, this court somewhat discussed the fact that the county clerk historically in San Juan had permitted magistrate judges to file their nominating petitions without division numbers. Should we consider the fact that the county clerk in this case did tell Ms. Dow that her nominating petitions that she filed, the screenshots, were sufficient?
And Your Honor, I'd like to say I am
Sorry.
Go ahead.
yes, I'm out of time, Your Honor, but
Go ahead.
if I might answer. I'm certainly, we would hope that, we would like for the situation to be to say, what exactly must be filed. But that said, I think that ultimately in this case, what we have is a situation where the petition it did not, ultimately what was on there did not affect the validity, authenticity, or number of signatures whatsoever. So I think it was correct to do so.
Thank you.
Thank you, Your Honor.
Mr. Eli, if you'd enter your appearance and
Thank you,
begin.
Chief. May it please the court, I represent Jaramillo, who's sitting here next to me. Thank you for allowing our parties to sit at the council table. Let me start. I think I'm hearing the justice's questions. Let me start with something basic. The election code has a balance. It's not an equal balance. It's a balance between the candidate and the challenger. The candidate has some basic requirements that are easy. They should be easy. We want people to be on the ballot. We want to give voters a choice. So what are they? You have to tell the voter who you are, where you live, what you're running for. And then the person signing your nominating petition under 1-8-30 has to provide three things: their name, their signature, their address.
Was that provided in this case when the voter went to the portal to sign the petition electronically?
I have no idea because I don't have access to the portal.
Well, we have a screenshot of that on page, what was it? 20, no,
22.
I believe it's 22. Justin.
no. It's page 12. That's what the voter sees.
Right.
When they go to sign electronically. They put their name, they check something for their usual signature, they put their address. All of that information is there.
Correct.
So is that the nominating petition?
It should be the nominating petition.
Is that available to anybody?
It is not.
Is that available to Ms. Dow?
It is available to Ms. Dow
How is it available to her?
because she has the passcode.
She has a passcode to get,
Word. Access to the portal.
Not print.
She can print it if she wants to. She can download the information. In fact,
She can download what's on page 12.
she can.
You're absolutely sure of that.
Well, part of the reason I split my time evenly with the Secretary of State is they're going to be the experts on all of this. And
I
I,
understand that, but you're making a representation that it's absolutely available to her to download and print and attach to her declaration.
correct. 126 of the 128 candidates were able to do just that.
They know what they filed was the PDF, which is on page 16.
All right, let's take a look.
Page 16 is different what's on page 12. Page 16 is a facsimile, is something generated by the Secretary of State computer from the information that's contained on page 12.
And that may be right, Justice. That may be right. That
Well,
this is what's actually.
So
filed.
my question again,
Yes, sir.
I want you to be very precise, what is the nominating petition? You first said it's what's on page 12. Now you're saying it may not be because what everybody else attached was what's on page 16.
I don't have to guess, Your Honor. I know exactly what the nominating petition is. It's in 1-8-30.
Okay,
And it
where,
is-
where of these different, page 12, page 16, page 22, which of those is 1-8-16? Be 1-8-30.
The one that, if I'm reading this correctly, if you're asking which one follows the statute, it would be on page 16 because it has the signature, it has the name of the person signing, and it has the address, as well as the heading that puts the candidate's name, what she's running for, and where she lives. And
Did the-
that complies
did
with
the
1-8-30.
voter Make that.
You mean,
Did the voter make what's on page 16?
when the
The
voter,
Secretary of State created that.
when the voter goes online, my understanding, I'll give you my understanding, the voter goes online and they see a single sheet, right?
They
They
see
don't,
what's on page 12.
they don't see what everybody else has signed. So they put in their signature. It is then filed. It's a convenience tool under 1-72E.
Is it filed in the sense that it was filed for purposes of the declaration?
It is
of
not.
candidacy? Okay, that's why I want to be really careful with. what-
Absolutely not. It is gathered. The
And it's
statute,
submitted to verify that the person signing the petition is a registered voter.
correct. But here's what's important. We keep talking about the voter going in and signing the nominating petition. But when we go back to that balance, it's the challenger that we have to focus on.
I disagree. I mean, and that's a tone of morpher, and that goes back to Anderson. I mean, Anderson says, we begin our inquiry by noting our primary concern is not the interest of the candidate, quite frankly. It's the interest of the voters who choose to associate together to express their support for that candidacy.
Correct.
What you're leaving out of your simple balance is those folks that nominated Ms. Dow. And that is why any impediment, which just seems like a bunch of impediments, quite frankly, to these folks to associate, because you don't challenge the nominating, you didn't challenge a name on there. So it's clear you must concede these were valid nominees. It just seems a little bit like a gotcha, quite
Justice,
frankly.
with all due respect, I can't concede that. I have no way of knowing that. Here's what happens. The challenger goes into the clerk's office, requests what's been filed by Ms. Dow. All right. They get back a signature and a name and cut off voter IDs. They don't get addresses. So now they've got, within this short window, this 10 days, which they should have. That's why I said the balance isn't equal. They have to now go and look to see in 3 counties.
Is there anything
Are
in the
these
record
legitimate
that
votes?
says the portal rejected a name as a valid nominee for Ms. Dow? Is there anything in the record?
No, but it doesn't, Justice, with all due respect, just because the Secretary of State, in fact, they put it in their brief. They admitted this. Just because the Secretary of State validates a signature doesn't mean that it's valid. For example, the Secretary of State wouldn't know if someone had signed another petition. They wouldn't know if somebody who listed their address had listed a lot or a business, which they're not allowed to do. That's why the legislature in no way intended to eliminate the ability of people to challenge. If that was true and the Secretary of State could just say, all of these are valid, then challenges are gone. And the legislature did not intend that. How are my people, when they go in and they see just a name and a signature and cut off bin numbers, given the ability within a 10-day period to adequately challenge those names?
Take it up with the legislature. E says a secure internet application shall provide for the ability to verify that a person signing the petition is a registered voter and is eligible to sign the petition. That's what the legislature said in 1172E.
Right. It does. And Justice, with all due respect, I'm telling you, the legislature did not intend, and it's not in here, that it is the be all and end all. Just because the Secretary of State says this is somebody on our voter rolls doesn't mean that somebody can't go out and challenge that nominating petition.
Can I ask you then, in this case, it's a candidate making a challenge and a political party. So section 11113 seems to permit both your client and the Secretary of State has access, but your client and the political party that requested it to use this database to look up the voters. Wouldn't that be the method? And again, specific to this particular case, that you would use to verify whether these individuals were in fact legitimate voters who signed the petition?
First, if you look at our Exhibit 2 to our amended petition, you will see that a number of bin numbers were cut off. We don't know. So those voters, we can't challenge, we can't look them up. As to the process of going out and accessing the database and contacting the county clerks, again, I want to be very careful when I say this. That is a more cumbersome process, but the experts are sitting right here behind me. And they can talk to you about that in 15 minutes, but the VIN number is going to slow everybody down. That's why the legislature was very clear. You have to have addresses. And that's what the challenger did not have. The challenger didn't have addresses. And if we want to write out that requirement of 1-8-30 or 1-1-7.2B, which says a person who signs a nominating petition shall indicate the person's registration address. That's not, if they've already validated the signature, that's not enough. That's for the challenger. That is, it's for the voter, but it's also for the challenger. The legislature in no way intended to eliminate challenges. And in this case, they have vitiated that ability of the challenger to adequately challenge. They've got a very limited period of time, and I'm not arguing that it shouldn't. The challenger should have a high burden to kick somebody off the ballot. The candidate has to be transparent. And in this case, Ms. Dow had plenty of opportunity to correct what was happening. She filed it at 11:30 in the morning. She could have said, let me see what's there. Does it comply with the basic statutory requirements of name, signature, and address?
Ask a question about Simmons and the sort of, it goes kind of what I'm wondering that the standard is here. Simmons talks about, we will not deny a voter's right to participate in an election absent bad faith, fraud, or reasonable opportunity for fraud. Is that a standard that we should look to? Because it seems like everything was done in good faith, or do we ignore that? Is it just that it was not printed out in the correct form and filed in the correct form. Because there appears in the record I've seen, there's no bad faith, fraud, or reasonable opportunity.
The Simmons in paragraph 15 also says, we will not construe election laws so liberally as to allow a candidate to receive a ballot position to which he, and I would add, or she, is not entitled. Paragraph 15. In this case, again, we're not talking about form over substance. We're talking about a challenger goes in, they receive the information 2 days after filing day, after having immediately requested the information. So they've got 8 days left. They're not given the addresses. Challenger is effectively foreclosed from going out, doing the investigation, finding out if the person actually lives, resides, the Secretary of State is not doing, resides at the address. It wasn't applicable in this case, but it could be in other cases. If they signed, for example, a hard petition, which they're not allowed to do in addition to the portal, and they would not be allowed to do that. The Secretary of State has no way of checking that. And in that situation,
Wait, the Secretary of State has a way of checking it. They have access to the portal.
but what's
But the
happening is,
challenger is a different story perhaps.
if, for example, you had 2 people running in a primary and one's going out, remember, the portal is completely voluntary. So you don't have to use the portal at all. So the Secretary of State is only checking what's on the portal. If some other candidate is out there in the primary signing signatures and has signed it twice, the Secretary of State, I can tell you, they will tell you, they're not checking that.
That could happen with paper petitions.
Absolutely. And the challenger would have the right to check that and find out. But
So-
in this case, how do they do that?
In this case, there was 2 challengers. The first one was dismissed on the basis that there was no prejudice to any of the parties. The second one proceeded, and it's now here before us. Did you demonstrate prejudice in being unable to get the access to the VINs in the court below?
Here's what, just to be clear, I voluntarily said to the court, and it's in the record, said the declaration of candidacy, while they didn't comply with the statute, was a technical error. There's no prejudice. In this case, I did put in the briefs the steps that would have to go through. So the Secretary of State, well, I want to be careful about this, Your Honor. I think they can talk to that. I'm not sure it's in the briefing, but they can talk about the cumbersome process of the VIN numbers. But what I did point out is some of the VIN numbers are cut off. And so,
But as to those that are not cut off,
yes, sir.
was there any evidence that there was prejudice in not being able to go get the information from the VIN number?
We did not go back and look at the VIN numbers. And the reason for that is there's no such thing as an autopsy in the election code. Once the 10 days has expired, we're done. There's no point in going back and looking at the VIN numbers to see if we can find.
Can I, so the Democratic Party requested the filings in this case.
Correct.
From what I can tell. I didn't see any follow-up request. Is there anything that would prohibit them from requesting the PDF that the clerk can so easily print according to the briefing? Don't know. Didn't have the benefit of electronic petitions back then, but it sounds like, couldn't that be requested by the party or whoever wished to? Why is that not something that can be requested?
Because at that point, it's what's been filed that the candidate has access to. So, I'm sorry, not the candidate, the challenger has access to. So if the justice is suggesting that they should have gone back and say, do more work and see what else is out there, that's not provided in the election code, and they didn't do that.
Okay, I just wanted to know, in the briefing, it made it sound very simple to, for the clerk to print it for the candidate. So I didn't understand why.
And then I guess hand it back to the clerk. I
Right.
think that's, I think some of the tone of what you're hearing here is like, is this really all that big a deal? Because the voter signature in document, what I'll call number 1, I think it's page 12, did what it was supposed to do. The clerk's office had it, and it was just ministerial for then fix this. If Ms. Dow had gone back in, say at 1 o'clock and said, ugh, can you print those for me? And now I'm going to hand them to you. And that's my filing. Is that what we're talking about needed to happen here?
We are not. This is not a ministerial mistake, and I wouldn't be here if it was, as demonstrated by the declaration of candidacy. This goes to the core of the election code. The candidate, it's their responsibility, nobody else's, not the clerks, not the Secretary of State, not DuckDuckGo's, because you'll see that she's blaming the internet. It's nobody's mistake except the candidates. The candidate has to provide this information because there's a clock ticking. So when you go and you request this information from the county clerk, and this is all they give you, yes, I guess you could go back, you could try to get the information, but the bottom line is they
not what
haven't
was
complied
filed.
with the statute.
Thank you.
Period.
Thank you, Council. Your time.
Thank you, and I'm sorry I'm out of time. Thank you.
May it please the court, I'm Peter O. I'm General Counsel for the Secretary of State. Mandy Vigil, the State Election Director, is at council table. And I would like to begin by addressing Justice Vigil's question. What is the nominating petition here? And as Mr. Eli stated, 1-8-30 defines nominating petition. It says, it shall be in the form prescribed, and then it is depicted in the statute provision itself. So the answer to the question, what the nominating petition form should be, is the one that is most like the form depicted in the statute as appears on page 16 of Mr. Harrison's declaration.
How does that then comply with the view that the voter has on when they go online to sign the nominating petition? Shouldn't it then look like what's in the statute rather than what Secretary of State has actually provided, which is singular page?
I see your point, Justice Bacon, but I think that's a function of what's available technologically.
But so are we saying if a different candidate, hypothetical candidate, say it's a statewide candidate, they submitted thousands and thousands, and they had thousands and thousands of signatures through what I refer to as document number 1. Could that be challenged as not compliant? It's not what the nominating petition is under your argument, because it's a singular page and it doesn't follow the pattern of what's in the statute.
Well, what ultimately gets filed is the PDF that conforms to the statutory depiction. How they get there, moving screen by screen, it's a lot like signing up to register to vote. The actual paper registration, voter registration form is not something that you see when you're at the motor vehicle department conducting a transaction, because it moves you through
So are
the
you telling
process.
me, 'cause I've not done this electronic thing and it post dates my signatures. Yeah, all of us. So if I go online and I want to sign a nominating petition for, Joe Schmo for county commissioner, I'm gonna see what is depicted in document number 1. But on the back end, if I went and said, okay, now I'm gonna print all of this out, PDF or otherwise, it's gonna look like document number 2.
That is what's supposed to happen. Yes,
Okay,
that is how it
that's
works.
very helpful for me to wrap my
Yes.
head around.
And that is what all the guidance that the Secretary of State has put out to all the county clerks and candidates in the various guides, the manuals. They emphasize the need to download your petition.
So it comes out in
So
that
it comes
format.
out in a PDF format that conforms to the nominating petition as depicted in 1-8-30.
So what is depicted on page 22? That's what was attached to this Representative Dow's declaration.
Right.
What is this? What is it in the Secretary of State's office?
We have been referring to that as a screenshot of the portal page.
I understand, but
Prior
what is that information? What is it? Do I make, what function does it serve in the Secretary of State computer?
This is the compilation of the information provided by the signee for a nominating petition. And it's in this form as it exists in the portal, which is what somebody took a picture of. But when you download it, you
So
export
it
and
converts
download.
this information on page 20 to the facsimile, which is on page 16. Is that what you're saying?
Yes, exactly.
Okay, so electronically, it converts this into what is on, so it's the same information.
It's the same information, except when you take a screenshot of it as has been done here, the screenshot doesn't cover all of the information that it ultimately downloaded and printed out in PDF form, as you see on page 16.
So if somebody with that knowledge looks at page 22, they know it contains all of the information that's on page 16.
Justice, when you say somebody, could you be more specific? You mean anybody?
Well, me, looking at page 22, I understand now that that contains all the information that is subsequently generated on page 16.
As it resides in the portal, yes. But when you take a screenshot of it as has been done here, it does not contain all the information that is shown on page 16 and which is required by the statute. For example,
It's got a code then, which would give you access to the address.
I don't think everybody can make use of the VIN quite like that, Justice.
What about the parties in this case? Were they able to make use of the VIN, the Secretary of State and the Democratic Party?
No, I think the point of the complaint is that they could not gather all the information that is required by 1-8-30 in the form that was filed with the county clerk, Sierra County. So it's our position that it's not far-fetched to say that whatever Ms. Dow filed, it was not a nominating petition. The nominating petition is defined in 1-8-30, and an example is provided for you to see so that there's no question about what a nominating petition is supposed to look like. Yes,
Can
sir.
I ask, return to the statute for a moment? So 1126A, I want to talk about that, and I want to talk about 117E. 1126A seems to do two things. One, it's as a nominee, I want to know who I'm nominating. Right? That's me as a nominee. And the other is, and you're talking to a panel who've gone through these petitions, is for the challenger to say, I have the information to know that that person eligible to nominate that candidate. Pretty simple. Legislature passes 1172E, and it says the secure internet application shall provide for the ability to verify that a person signing the petition is a registered voter and is eligible to sign the petition for the particular candidate. Is it the Secretary of State's position here today that that portal does not do that, or does it do it? Does this process we're talking about verify that that individual is eligible to sign the petition for that particular candidate?
Justice Thompson, yes, it does.
Okay, then the two purposes of 1126A are served. They know who they're nominating, and we know they're qualified. Now, to me, and I'll let you answer, everything else just seems to be form over function. So help me with that.
The vendor that the Secretary of State retained by contract to provide this program has set it up so that when a person signs online a nominating petition and provides the information that is being asked of them, the program will check against the voter registration rolls to see if that person is on the rolls and the address is as registered. Now, bear in mind that that's a point in time validation. So at the moment of that transaction or the signing of the petition, yes, that person is registered to vote and lives at the address that is shown on his voter registration.
Does it verify that the address is within the district they're signing
Yes.
for?
Yes.
Does it verify whether the address is a lot or a commercial
No.
space? And does it verify whether somebody is signed twice?
No, they can't do that.
And those are not the lot and whether they've signed twice, to my recollection, are often bases for disqualifying signatures.
A vast majority, yes, Justice.
Can you just, again, I apologize, I didn't get a real clear answer, and maybe you did answer this, but section 111.13 allows a candidate, an election-related organization, or an election observer to use the VIN number to find out about the address and all of the voter information. Is that something that could have been could the candidate and the Democratic Party in this case use the VIN number to get this information, to do a challenge?
Justice Zamora, yes, my answer to that question is yes. I think the focus of the Secretary's interest in this case is more than just form over substance or function. The Secretary of State is by statute the chief elections officer, and she's charged with the responsibility of obtaining and maintaining uniformity in the application and interpretation and operation of the election code. This very question and all of the issues we have discussed here today only point up the importance of having uniformity in this process. Bad fraud or a bad intent or fraud, as was mentioned earlier, we don't want to start down the road of trying to figure out all of those things. It's simple enough to use the form that has been prescribed by the legislature. Everybody does it. It's not that difficult. In fact, in this last election cycle, no other county clerk accepted screenshots of nominating petitions. They all did the simple task of accepting the forms that have been authorized by the legislature. So
Can I ask you a different kind of question? I believe there's representation in one of the pleadings filed in this case that there is another unnamed candidate out there who was removed from the ballot for the same mistake. Is that something we should take into consideration here, that there will be potentially two different outcomes, depending on what the court decides to do?
Justice Bacon, that individual was also a candidate in the Sierra County clerk as the filing officer. So the point I'm trying to make is
It's unrelated to the point you're trying to make. And I'm just curious because there's an assertion that somebody else has been kicked
Right.
out.
Right.
Ballot for the same thing. They're not in front of us. So they would continue, if we agree with Ms. Dow, she would be on the ballot and that other individual would not because they're not in front of us. And is that something we should be concerned about?
I think it is. The consistency or lack thereof in this case should be a concern, not only to the Secretary of State, but to this court. So,
Well, and the other candidate.
yes, there's that. So The thing that I would point to, again, is that when the Secretary of State is the proper filing officer for statewide elections, our rotunda area at our office is just filled with people carrying bankers boxes. And for the big races where thousands of signatures are required, the candidates bring extra people because there are so many boxes. This process is a very well understood and followed procedure. And I think the benefits of a uniform process, as opposed to engaging in all of these
The
what ifs.
Secretary of State's declared uniform process. The Secretary of State could have declared that what the voter sees when they go to sign the petition on page 12, but that is the nominating petition. Could have said that.
I beg to disagree, Justice Field.
So
because
you're saying that what the voter sees on page 12 does not satisfy the legal requirement of a nominating petition?
No, I think my distinction is what the voter sees on page 12
And fills out.
and fills out is not the end product that ultimately is supposed to be filed in the form.
That's because the Secretary of State says so. But the Secretary of State never adopted rules to say that with public input and comment.
I do concede that there is no administrative rule addressing the subject, but again, I insist on.
One thought I've had going over all this is it seems like on the one hand, the statutes seem to be referring to the old paper nominating petitions. And then they put in this electronic thing. So we're trying to mix apples and oranges and hopefully and doing what we can to make them mesh when they're really different. And maybe that's more of a comment than a question, but you have a reaction I'd like.
Yes. My response is that there are other statute provisions that address how the nominating petition process, the filing of them, not the gathering of them, the filing of it is to be done. 1-8-27 says that you have to file the declaration of candidacy and the nominating petition. 1-8-28 says that it shall be done on the second Tuesday in March between the hours of 9 and 5. And then the other statute says that you have to do it in person. So when you take all those together in conjunction with 1-8-30, which defines what a nominating petition is, the ultimate product that you're supposed to be handing to the proper filing officer, all of those statutes provide the process as the legislature saw fit.
Well,
Thank you.
I'm sorry.
Do you have another
No.
question? Any other questions? Thank you, counsel.
Thank you.
Just a second. Let's get the clock set for 5 minutes, please. Thank you. You may proceed, Mr. Harrison.
Certainly, Your Honor. So I have 4 minor points and then 1 relatively major point based on things that the justices have asked or my friends on the other side have talked about. First, Your Honor, Justice Bacon, you brought up the case in McKinley County of another
I don't
putative.
know where it is.
It is a strange, it's at the record proper at 32, and we don't have what the nominated petitions themselves look like. We also don't, there was no court case filed, but it is a strange letter. It is dated 2022. It refers to the 2026 primary election. It then refers to the 2025 regular local election. It is a very strange document that I have no idea what to do with, and I can't tell what it means. Number two, the duplicates issue. So I think my friend on the other side may have misspoken slightly. The system does does invalidate or basically prohibits you from signing duplicates, either cross-candidate duplicates or the same.
If it's electronic,
If it's electronic,
but
that's
if you're
true.
using paper as well,
That is
you're not going to be
correct, Your
able
Honor.
to.
Now, I should note that's a counterfactual here because there was no primary opponent for Ms. Dow. She's unopposed in the primary.
Understand, but we're have to write something that's going to be broader than this case.
Absolutely.
Okay.
But it should be noted, she's unopposed in this primary. She also didn't use any hard copy petitions,
Right.
so there's no possibility.
I do want to clarify that for the record. All nominating petitions were signed electronically. There was not a hybrid of both.
That is correct for Representative Dow, yes. Secondly, interestingly, so Ms. Vigil in her testimony, it's at 1 hour, 48 minutes and 26 seconds through 49:10, stated that her office would have accepted screenshots of what I'm calling the original online petitions. The, I think, page 12 petitions that you refer to document 1 petitions, which I thought was interesting. I'll tell you, it is not clear to me because we have not had access to the portal, whether those things actually exist or whether they become data when you submit them. But it is interesting that the Secretary of State has gone on record saying, yeah, we would have taken those we would have taken, it would have been a big stack, right? Because they're no longer 10 per page, but we'd have taken those things, which kind of indicates a level of, first, they're not claiming there's one in particular petition, but they're acknowledging that what matters is the 1-1-26 information. We take the position, obviously, what matters is if the voters saw that information. And it should be noted again, the voters have the exact same experience signing for Rebecca Dow that they did for any other public office candidate in the state. Third, Justice Bacon and Zamora asked a little bit about the voter registration system and how it was available. Rule 1-96E 2 through 5 requires, as part of your nominating petition challenge, that you describe, quote, the voter registration records upon which the challenge relies, quote, the person who searched the voter registration records, quote, any variations in the name, spelling, or address for which the search was made. Now, what Justice Bacon made the point that, well, there's nothing that requires, there's a lot of stuff that talks about availability. You're kind of left with IPRO, which of course is an inadequate time frame. I'd make the same comparison to 1-8-34B, which is how you get the nominating petitions in the first place. You have to call the filing officer and ask for them. It says that they should be at a nominal cost, but doesn't say anything about how quick. Now, obviously, I've always, if a filing officer is slow walking, you've got to tell them, look, I've got a statute of limitations that's 10 days. I need them now. But the reality is there's nothing in the statute that actually says you get them timely. It's just you have to read it in. And I would say the same thing applies. When the rule requires you to have access to quote, voter registration records, just the way it is these days. And then fourth, so we've talked about the perspective, and I've tried to address it head on, the perspective of a potential challenger, which again is not a totally illegitimate point, although a lot of his complaints are more rightly directed toward the filing officer and the Secretary of State for, again, not providing him with what we'd say are the documents he probably should have gotten. We've talked about the perspective of the voters, which again is indistinguishable for Rebecca Dow's signatories. They had the exact same experience and got the exact same information they would have gotten for any other candidate in the state perfectly. This is purely a matter of the printouts. Let's talk about, again, the perspective of Rebecca Dow. She went to the clerk to figure out how to do this. The clerk sent it to the Secretary of State. It's described in the declaration as well as on footnote 21 at page 55 of my certificate. She was on the phone with the Deputy of Elections who walked her through, in his words, not hers, walked her through the print process. She got a confirmation email. That picture of that email is at the record proper at 2:25. She looked at them. She didn't recognize that they were wrong. She'd never seen them before. There's no picture of them in any of the guides that even the Secretary of State references. And so she turned them into she didn't know they were wrong. She turned them to the clerk who also thought they looked fine, and also considered the full context of the Secretary of State having her walk her through the process.
So what does all that mean?
So,
Faith standard?
well,
If we were to say technically didn't do it, let's just say it's written that way. Technically didn't file what looked like is in one dash, what's in 30. Are you asking for what I read in Simmons, or what is your standard?
I would point the court back to Charlie and Duran, both of which dealt with the district number problem that, and found that, yeah, you need to have your district numbers. That was Charlie, but we're not going to, given the traditional practice, we're not going to kick you off the ballot. It would be unfair to your voters. Duran, by the time of Duran, the statute pretty clear. And still, again, the court said, you know, given the ambiguity, we're not going to apply the harsh standard of invalidation. If there is a close question here, democracy should prevail, Your Honor.
Well, I think we agree on that.
Thank you.
Thank you.
We are going to recess and discuss and see if we can reach an agreement, at which point we would announce it to you. If we cannot, we will advise the clerk, but we'd ask that you stay in the courtroom or close to the courtroom until we let you know what we're going to do. So, court is in recess.
And the floor, please.
Please be seated. First, I'd like to thank council for their very helpful briefs. We did this on a very short time frame, and you managed to provide us with some very good information, so we do appreciate that. The court has come to an agreement, and it is unanimous in its outcome. The district court is reversed. The Secretary of State is directed to put Representative Dow's name on the ballot. And we're announcing the outcome here due to the expediency of this case, but it will be followed up with an order and an opinion soon. And council, any questions? Thank you. Court is in recess.
And for the